Wow, hello for the second time this afternoon. We have been going through many points related to all of the subjects of the IPR since this morning, from copyright to industrial property. Yeah, there will be still plant varieties, but not much in reality, right?
Nó không nằm trực tiếp vào cái
Now something not directly related to any specific subject, which are the so-called common issues, overall issues in the revised law and decree number 65 also.
dung.
The common contents are quite numerous in terms of the quantity, 7 of them. However, each of them will be quite brief. First, the regulation on the application of law. Secondly, the state management policies. Third, the handling procedures, complaints, production of the experience piloting test, representative ownership, and then on the unfair competition. 7 of them. So first of all, on the application of law. In the past, it was in article number 5, but article number 5 has now been removed. Why? Because it is overlapping, repetitive, and not ensuring consistency with other related laws like civil code, the law on promulgation of legal normative documents, or the law on international conventions and agreements. And also article number 8 revise and add to say that the state policies will be supportive financially with the tax incentives and carried investment incentives to encourage innovation and make exploitation or tapping of intellectual assets or property. So the innovation has become a keyword quite frequently used these days. Now the regulations on the applications handling procedures. In fact, my colleagues mentioned earlier, so I will be very brief. The previous version of the law only stipulates on the third person or the third party opinions in 112. Now article number 112A mentioning that the third person, third party opinion is now only a source for reference. Viet Nam is not obliged to respond to the opinion. And the handling procedures is clearly concretely stipulated on the terms of effectiveness and also on the fees and charges. Yeah, so we now have 112A. And on the regulation on issuing the kind of certificates for protection, maybe you pay great attention to that, right? So the issuance of such certificate paper in 118.1A specifically, I will speak in more detail about this. In the past, let's take an example of a trademark. In a trademark application has 2 groups. There are 2 groups, one of which is rejected and the other one might be protected. That is in the past, right? For that case in the past, the decision will be rejection, refusal. And if the applicant fails to answer or his or her answers is not sufficient, the IPO of Viet Nam will officially reject. But what is now? It will be different. The IPO of Viet Nam will not issue the notice of rejection, but in issue a notice of granting the certificates, saying what is okay, what is not okay or not okay. And if the applicant does not reply the IP of Vietnam will give the official notice saying that this part is approved, that part is not approved. Not rejecting wholly, no, different from the past. So it is more facilitating for the applicant, right? Now the new things on complaints, regulation on complaints. Yeah, this is bearing something quite specific to this domain of IPR. The foundation for this clause 5, article 3 of the law on complaints stipulate that if other laws have different stipulation on complaints and handling complaints, application will be in line with the stipulation of that law. So we can take the law on IP to take of this. And on the way to lodge the complaints, Vietnamese or foreign entities, which means organization, individuals who are resident in Vietnam or having the business manufacturing facilities in Vietnam, can lodge the complaint directly or indirectly. Or for other cases, entities which are non-resident and do not have manufacturing facility in Vietnam, they will lodge the complaint via their legal representative in Vietnam. So it is quite correct, right? And something new also that it is in the form of the complaints. So it can be not only the paper, in the form of paper, but also electronic form is also accepted. Article, paragraph or section or clause number 4. In case the complaint related to the registration right or other contents which need re-examination, the complainants shall pay the fees for re-examination. And lastly, the complaints and handling complaints which are not fall under category of this law will be carried out in line with the law on complaints. For the duration, when re-examination is needed, the timing for re-examination and the timing for the complainants to revise the dossier shall not be included into the duration for handling the complaints. And we can refer to 119 article of the previous version. The re-examination can be 2/3 of the time of the first time of examination. The next one revised is on the protection of piloting data in Article 128. This is related to pharmaceutical and chemical, agrochemical products. Clause number 3 is added with the regulation related to the obligation to ensure to secure opportunities for the right holders to perform the right to this patent, which is in line with the CPTPP agreement. And for the agrochemical products, and these are the full contents of 128 with the additional clause number 3 on pharmaceutical and number 4 on agro and chemical products. And part number 6 is on the new things on the representative of industrial property. Article number 153, removal the obligations of the charges and service fees. As you can see on the slide, it has been removed. 154 remove 154 now allows the entities or the organization need to have only at least one individual with the practitioner's certificates, not the leader or the person authorized by the leader as per the current legislation. So it is more facilitating. On the conditions to perform the service of industrial property representatives. Two domains, two categories are divided into with the conditions to issue practitioner certificates. The first domain is trademarks, GIs, commercial name, unfair competition, business secret. Number 2 is on patents, industrial designs, and arrangement. And something the doctor liked very much. Article 1 allowing Vietnamese lawyers who have undergone the training courses by MOST, Ministry of Science and Technology, will be issued with the practitioner certificates of industrial property representative. We have received nearly 100 dossiers from lawyers applying for that. They are being examined. So there will be, in the upcoming future, many representative cards, the cards for representative of industrial property to be issued. Article 156 with the revision on the revoking of practitioners' certificates if the person in question does not meet the demands, requirements of the certificates. The transitional regulation, those issued with the practitioner certificates before the day the law takes effect can continue practicing the jobs in line with the certificate issued earlier, and those eligible via the test before the taking place date of the law will also be handled in line with the previous law. The last part, it is on stipulations on unfair competition in Article 130, added with the stipulation on unfair competition in related with the domain names. Only that is when nothing done is bad faith, and for the illegal gains. Only in that way the behavior constitutes unfair competition, and it can led to the retrieval of the domain name. And point D, clause 1, article 130, changing, registering, and occupying the rights into chiếm hữu, occupying or owning. So that is some of the new points in the revised law, which are not directly aimed toward right holders as in other presentations you have earlier today. So it contains new things, and it opens opportunities for you who are professional professional representatives of IP can obtain a card for that, representative's card. Thank you for the attention.
Sorry, so I'm now switching to English. Okay. Just a bit about myself. I'm an outside expert of IP key SME Helpdesk in Southeast Asia. I'm a lawyer and I'm a principal general manager of Rouse in Vietnam. I've been practicing in IP for about 18 years. And it is my honor to be here on behalf of the IP Key SME Helpdesk to raise some concerns from the European Union businesses operating in Vietnam relating to some of the provisions under the new amended IP law and the guiding decrees. Okay. This is a bit of introduction about what we are. So the Southeast Asia IP SME Helpdesk is an initiative of the European Commission, which provides free, confidential, business-focused advice to small and medium enterprises and intermediaries in the European Union and other countries of the Single Market Program, for example, Norway, Iceland, Ukraine, etc., relating to intellectual property rights in Southeast Asia. On this slide, you can see the range of service offered by the Helpdesk. Firstly, through the inquiry Helpdesk, you can send any IP questions related to Southeast Asia to the Helpdesk and receive a reply within 3 working days. Secondly, the Helpdesk organizes monthly training workshops and live webinars, which is tailored to the need of SMEs across Europe and Southeast Asia throughout the year. Please feel free to subscribe to the newsletter that we provide and connect with the team on social media to keep yourself updated on the upcoming activities. The Helpdesk also gives you an access to a wide range of publications in terms of country fact sheets, industry-specific IP guides, or general IP guides on various topics. These guides can be easily found on the Helpdesk website that we provide a link there and also an address there. Last but not least, the Helpdesk also offers interactive learning tools, for example, e-learning modules, which is also available for download from the official website. Okay, so this is a brief agenda of what I'm going to cover today in my presentation. As you all know, with the issuance of the new amended IP law to implement Vietnamese obligations under major international treaties and trade deals that Vietnam is a member, including CPTPP, the FTA signed with the European Union. Vietnam has, made a major step in overhaul the IP system of the country and makes it the IP system of Vietnam to be a very modern one, and in our opinion, only second to Singapore in the region. So the businesses community very much welcome the amendment of the IP law and also the issuance of the Guiding Decree 65 issued by the government in late August. However, there are still some small concerns and questions from the European business community, which we would like to raise in this forum, just for our further discussion, further clarification, and we would welcome any further meetings, further dialogues with the IP Office of Vietnam, also the Copyright Office of Vietnam and other authorities to take this forward. So I would like to cover 2 main parts today. The first part is relating to IP prosecution matters. The second one is relating to IP enforcement matters. First of all, for IP prosecution, there are some still open questions relating to patent prosecution, specifically relating to the first filing requirements under the new amended IP law. So under Article 14 of Decree 65, that provide guidance for Article 89, Section A of the IP law on first filing requirements for security control of invention, including utility solution. Now, this provision attracts a lot of discussion and a lot of clarification from investors coming to Vietnam, because their inventions might be made by Vietnamese citizens working for them and also curated within the territory of Vietnam. So we would like to present some of the concerns here and also seek to further clarification of the open questions that they have. So according to that articles that I just mentioned, inventions,
Vâng, các cái giải pháp trong các cái lĩnh vực chuyên môn mà nó có ảnh hưởng đến an ninh quốc gia hay là quốc phòng. Vâng, thế và liên quan đến các cái công dân Việt Nam, những người mà sống tại Việt Nam hoặc là những cái tổ chức mà được thành lập theo cái luật của Việt Nam, và xác định các cái can thiệp rồi là các cái giải pháp đối với các cái đơn nước ngoài nếu như mà các cái can thiệp đó các cái đã được nộp ở Việt Nam để có thể được kiểm soát về mặt an ninh. Vâng, tôi rất là xin lỗi tại vì ở đây có thể là có một số những cái thuật ngữ rất là chuyên ngành, chuyên môn, và tôi rất là hy vọng rằng là các bạn phiên dịch vẫn có.
I will try to speak maybe slower so that you can work on the translation. Thank you. So the provision that I just mentioned, there are some still clear issues. Sorry. Oops. Sorry. Yeah, so you can see in this presentation the issues and some recommendations that we put on the slide. So the first open question is, what constitutes an invention or utility solution created in Vietnam? Specifically, whether it involves the whole or just part of the invention. So we understand that this hasn't been clarified under Decree 65 or the amended IP law. And in some workshops, we understand that the answer is yes. You know, whether whole or part of the invention, if that created in Vietnam, then that it trigger the first filing requirement. However, to make it clearer and more specific, we would like to suggest that maybe Vietnam includes such clarification in a legal document or official guidance, for example, in a circular to be issued to guide the implementation of Decree 65. The second question is, if the registration right of an invention or utility solution belongs to both a foreign entity and a Vietnamese entity, are first filing requirements obligatory? So again, this is also not very clear, and there is no official answer in the Decree 65. And we also understand that in some workshops, the answer is also yes. Then, you know, regardless of whether it belongs to a foreign entity or Vietnamese entity, belong to both of foreign entity and Vietnamese entity, then that's to trigger the first filing requirement. And again, we also recommend that this clarification is to be included in a circular to be issued in the coming time. The next question is, what are the specific requirements for technical fields that affect national defense and security? For example, you know, Item 4, Annex 7 of Decree 65 has provided a list of technical fields that affect national defense and security. However, we think that further clarification is necessary because the technical fields are overly broad And there are some devices or inventions are actually both for national and civil activities. For example, security cameras, for example, radar, for example, image processing chips, wireless communications, etc. So we think, that there are open questions that if the first filing obligation applies, then does the patent applicant need to mention that their technologies or device under the invention utility solution are used in intelligence, counter-espionage, or criminal investigation activities? Do they need to mention that in the invention description to trigger that first filing requirement? Or regardless of whether mention it or not, the simple fact that the device or the technology itself fall under the technological fields that mentioned under Decree 65 is sufficient to trigger the first filing requirement. There is also another question relating to first filing obligation that we would like to mention here. Is that Decree 65 specifies that if an invention or utility solution is subject to that first filing requirement, a patent application must be filed in Vietnam under direct national application or a PCT application before being filed abroad. We think that, and also talking to European businesses, we understand that this requirement is a bit strict and not very flexible, because in many cases where IP owners, especially those small and medium enterprises, they do not prefer to file via PCT. They only want to file in a number of small countries. And they may not want to file it in Vietnam first, given the business strategy and also market consideration, especially those who only manufacture in Vietnam for exclusive exportation. So these are the open questions that we would like to present here for your further consideration. And we would like to provide some suggestions here. First of all, maybe, still the first option, which is first filing the patent application or PCT application originating from Vietnam, but further clarification relating to technical fields need to be provided. Or if the applicant understands that they fall under the technical field that's subject to the first filing requirement, then they can file a request for security control with IP Vietnam, for example, and that could be carried out in a simplified procedure. So maybe the claims of the patent or the inventions, utility solutions, must be very simple, just in order to assess whether there is an obligation of first filing in Vietnam only. The next issue is relating to trademark prosecution, and especially relating to well-known trademark protection. First of all, we very much welcome the amendment of the IP law facilitating well-known trademark recognition under Article 4.20, Section 79. Section 75.1, which modify the well-known trademark definition to specialize public perception and reduce the criteria required for well-known trademark validation. However, there are still some issues, concerns here that we would like to raise for your kind consideration. First of all, we see that there is no specific provisions on authorities' roles. Here is IP Viet Nam and the court in examining and recognizing well-known trademarks. So this has caused some obstacles to trademark owners for establish and enforce their rights even with the required evidence. There is an argument that well-known trademarks is being protected via registrations already. Then why IP owners are really concerned about well-known trademarks recognition? Well, that may not be the case because well-known trademark is protected and not really depending on whether it is registered or not. And in some cases, IP owners really want to have their trademarks recognized as well-known to enforce their rights in the market, or simply just to file an opposition with the only mention that their trademark is well-known without going through the step of submitting a lot of evidence every time they file an opposition or invalidation against third parties that are very close to their well-known trademarks. So we recommend that maybe a specific mechanism for IP Viet Nam and the court to recognize well-known trademarks is established in the coming time. The final part under IP prosecution is relating to industrial design prosecution. First of all, relating to the requirement on certified copies of Hague designations. So we understand that under Article 24.8 of Decree 65 requires a certified copy of the priority application for the Hague applications within 3 months of publication. And failure result in the loss of priority rights. The issue here of concern is that given that Decree 65 has immediate effect since its issuance of the 23rd August, then that poses a timing challenges for foreign applicants. So our recommendation is that IP Viet Nam should provide perhaps a flexible solution for foreign applicants to fulfill this requirement, which is very time sensitive for designs filing via the Hague system prior to the date of becoming effective of Decree 65, which is the 23rd of August. For example, the solution can be that extend the effective date of the provision so that foreign applicants, they have time to meet with this requirement under Decree 65. I'm sorry, this is the final part of the IP prosecution, I promise. This is relating to the opposition procedure for international filings. We understand that Article 112 and 112A of the amended IP law allow third parties to submit opposition against registrations of trademark design anytime before IP Viet Nam's final decision. And also oppose the registration of a concerned trademark. The first one is submit opinions, and the second one is oppose the registration of a concerned trademark design within 5 months from the date of trademark publication or 4 months of industrial design publication. And we understand that opinions are only for reference, while opposition's proceeding is actually a legal proceeding. So the issue here is that international designs filing through the Hague system and international trademarks filing via Madrid system doesn't have an opposition procedure under Decree 65. And this has limits third parties' rights considered to national filings. So as you know, the use of the Hague system and Madrid system has increased significantly over the past few years, given that it is sufficient in terms of time, resources for the applicants, and it seems to be preferred, especially for companies that operate in various countries. Now that has caused some issues because if there is no opposition procedure for IR filing via Madrid or design filing via the Hague system, then they cannot file an opposition, which is, possible against the same trademark or the same design if they were to file via the national route. So our recommendation is to establish an opposition procedure for international filings. Okay, and the last part of my presentation today, I would like to focus on issues relating to IP enforcement. First of all, relating to expert opinions in IP enforcement cases. So, expert opinions, as we all know, is not compulsory to support a complaint against acts of, for example, trademark infringement. However, in practice, enforcement authorities always require IP owners to submit an expert opinion before considering the request to handle enforcement from IP owners. And it's usually the case that IP owners seek expert opinions from VPRI, Viet Nam Intellectual Property Research Institute, before submitting a complaint. Now, an assessment conclusion of VPRI will act as an initial ground for enforcement authorities to inspect or carry out a raid against the counterparty or the alleged infringer. Once the concerned products are seized, enforcement authorities, in terms of practice, still require IP owners to provide another assessment request to VPRI, or they can, and based on the same seized products from the raid. So it seems that this is a bit redundant and costly to IP owners because assessment is carried twice against the same products. And the first is the VPRI conclusion provided by IP owners. And then the second is also VPRI conclusion, but requested by enforcement authorities. So we think that given this is redundant, and also in the first place, expert opinion is not mandatory, then this has caused some difficulties for IP owners in enforcing their rights. In addition, there's also the case that they have seen in practice that there are conflicting expert opinions issued by VPRI and IP Viet Nam on the same matters. So usually IP owners are the first to request expert opinion from VP before they submitting their request to enforcement authorities. When knowing of that expert opinion, the businesses on the ground have seen some cases where the alleged infringers seek expert opinion from IP Viet Nam on the same matter, and there are conflicting opinions that reported, issued by VP and IP Viet Nam on the same matter. And this has caused a lot of difficulties for both enforcement authorities and trademark owners alike. Even they follow the legal procedures, and that also hinders the IP owners' ability to assess the likelihood of success in enforcing their rights and causing uncertainties in enforcement proceedings. So the recommendation here is that maybe Vietnam only designate one agency to provide expert opinion for each case to avoid having conflicting expert opinions, or encourage enforcement authorities as they handle more and more cases. They would have much more experience and expertise, and then encourage them to handle IP infringement cases without resulting to any expert opinions, especially for very simple and straightforward cases. Now, I would like to spend a little bit of more time in presenting some issues relating to online enforcement, especially relating to ISP's responsibilities and notice and takedown. So, as you all know, ISP or Internet Service Providers are categorized as intermediary service providers. Generally, they are liable for addressing IP infringement on their platform, including using technical measures and cooperating with authorities and IPR owners. Now, there are some exceptions that apply to ISPs' liabilities if they can prove that they are not aware of such infringement occurring on their platforms. But as soon as they receive notice coming from IP owners, they remove the infringing listings. So now I'm going to talk a little bit about the specific notice and takedown of IP infringement. The ISP must establish a means to receive notice and takedown requests for IP infringements. Now, with the booming of e-commerce, especially so after COVID, there are a lot of concerns coming from IP owners as well as authorities, given the surge of counterfeits and infringing products on such online platforms. So the procedure to be put in place by ISP is very important. Because without it, it will cause major difficulties for IP owners to tackle infringement or counterfeits, and also cause major concern for authorities to protect the legitimate interests of consumers. So usually, a notice takedown procedure will include IP owners or any third party can submit a complaint. Then there will be some verification process of the e-commerce platform. there may be some counter response from the sellers or the account owners that have been reported by IP owners that they're selling counterfeits or infringing products. And then the final part would be the content removal and sanctions application. So from our observation, in practice, most of the major e-commerce platforms that we've seen operating in Vietnam have a specific procedure to handle notice and takedown. And some platforms, even they have their own team to handle the request or even proactively remove the infringing listings that they are aware of from their platform. So, and some platforms also do provide room for the seller and IPR holder to exchange before their final decision. Now, these are a very encouraging developments that I've just mentioned relating to the steps taken by ISPs to help tackle the increasing complex problems of online enforcement. However, the outstanding issues and major concerns for IP owners here is that, first of all, the platforms are still quite passive in taking actions, and their actions are mainly based on IP holders' complaints. And increasingly the case that platforms are struggling to deal with a very high number of reports from IP holders. For example, they must handle maybe 1,000 of listings per one request by IP owners, and that is only one day working. And then the next working day, they need to deal with another request that involves another thousands of listings on their platforms. And among those listings that the ISP or e-commerce platform need to handle, a lot of them are repeated infringement. And there is still no education channel for IP holders to educate infringers on such platform. And that can be used, effectively to reduce the number of listings that ISP need to handle if infringers are fully aware of their actions that are infringing others' rights or selling counterfeits, and they will hopefully refrain from future infringement. Another difficulty is relating to inconsistent required documents from ISP to support the claim from IP owners. And you will see that in later slide. But for now, I would like to also raise another difficulties in dealing with online enforcement is that usually when the e-commerce platform made a decision of not removing infringing listings, then IP owners, they can't challenge the platform's decision unless they bring the case to the authority. For example, we actually aware of some matters where IP owners provide even expert opinions given by VP to the owner of e-commerce platforms, and based on that, requesting the e-commerce platform to remove infringing listings. And we would have thought that the owner of e-commerce platform would comply right away, because that is the action expected out of them, so that they are entitled to enjoy the safe harbor provided by the law. However, in practice, things are not that simple, and the team that handle the requests from IP owners of e-commerce platforms simply don't agree to remove infringing listing for various reasons. So if IP owners need to submit requests, that platforms do not adhere to their obligations to authority every time that e-commerce platform refuse to reject removing infringing listing, that would place a burden on IP owner's side as well as the authorities' side. And take for example, when coming to enforcement authority, IP owners need to provide identification of infringers. And that information are known to the e-commerce platforms. And some e-commerce platforms, they don't agree to provide such information, users' identification, to IP owners. So this is a problem of chicken and egg, because IP owners need to have that information to challenge ISP's decision before authority, but they cannot have it unless the e-commerce platform provides such information to them. So this is an example that I shared earlier about the inconsistent requirement from e-commerce platform on the same matters. So on the left-hand side, you will see the listings, same goods, same seller. But on the right-hand side, you would see the result, the outcome, given by the e-commerce platform. And there are obvious consistencies, sometimes they reject, sometimes they agree. So, to deal with these increasingly complex problems, we have thought about that. We also spoke to the relevant stakeholders, and we would like to put forward some recommendations. First of all, set out in a sub-law document, maybe a decree or a circular, a responsibility for e-commerce site or e-commerce platform to block infringing products from relevant keywords in the search engine. So, for example, IP owners can request e-commerce platform to include their trademarks as a keyword. And whenever seeing such keyword pops up, and not coming from the authorized sellers of the IP owners, e-commerce platform must have a filtering system that do not allow sellers to upload that infringing listings to the platform. This is a preemptive step that can helps reducing the number of listings on e-commerce platforms. Now, there are actually a provision already under Decree 52 governing e-commerce, Article 36.9, which allows, which set some obligations of e-commerce platforms. Then under that article, the law provides that e-commerce platform must regularly update keywords according to recommendations from competent set management agencies and filter information by keywords before information about goods services is displayed on the website. And we believe that that suggestion is only a further step coming from that specific provision under the law. The second suggestion here is to impose heavier sanctions on repeated infringers. In practice, some e-commerce platforms, they have policy to ban accounts or sellers that repeat the infringement a lot of times. However, not every e-commerce platform have that policy. And secondly, there are strict conditions for e-commerce platforms to ban such sellers or accounts that commit repeating infringement. For example, some e-commerce platform, they have a credit system where within maybe 3 days or 5 days, then if the seller still committed infringement and although were removed listings but are still committing infringement, then they will be banned in the e-commerce platform. And the final suggestion would be to enhance online to offline enforcement action. And we really encourage, enforcement authorities and other authorities such as the IP Office of Viet Nam and Copyright Office of Viet Nam to work more closely with the e-commerce platform owners so that the online enforcement issue can be tackled effectively and sufficiently. So with that, I'm now closing my presentation here. And this is the link to the website of the IP SME Helpdesk. Feel free to subscribe and using this QR code as well. Thank you for your attention.
I'd like to respond to some of the points raised by Ms. Yen. I see that the questions sent to us, addressed to us, aimed at us. We do not have time to respond to all of her questions, but I would like to have some points. For example, in relation to the famous trademarks.
Tôi không nghĩ là pháp luật Việt Nam.
I do not think that Vietnam legislation have a few authorities, competent authorities. Given Article number 74, it says that a trademark shall not be registered if they overlap with a trademark considered to be famous. So we consider that. And when anyone thinks that his or her trademark is famous and the registration of another person's trademark can fall into the category of Article 74, he or she can provide evidence so that IP office will take that into consideration while handling the application. If they found that the evidence is enough, saying that the trademark is famous, So if we see that it's in violation of Article number C4, IPOFIS of Vietnam will reject, will refuse, based on two reasons. First, we consider that trademark is famous, and if we let this one to be registered, it will cause confusion. So what is the mechanism to protect the famous trademark? In line with Article number 74, the right holder can be against the registrants, and the applicants will be handled by whom? Only by the IP of Vietnam. The IP office will not issue a decision saying that trademark 1 A, trademark B is a famous trademark. No, we do not issue such decisions, but we can consider the dossier, the applications, and if we see that that is a famous trademark, and we will take that into consideration when dealing with the application. And of course, in the decision to reject, of course, we will have to show the control trademark which is famous. And in Article number 129 on the infringement of the rights, if the owner does not register and another person uses that and a lawsuit is brought into the court, so he or she need to prove that his trademark is famous. And if the court says that this is the infringement, the court shall have to quote the argument of the plaintiff. That this is the that is really a famous trademark. So we can say that there are no competent authority in Vietnam in this regard. So the court shall not issue a decision either saying that that trademark is famous. What the court does is to decide whether the trademark is an infringement or not. Secondly, in relation to the opinions, when you said about the examination, for the examination, there are quite diverse wishes for that, and I will have to affirm that the Vietnamese legislation, you, Ms. Ian, also mentioned the encouragement of implementing agency to always to keep consulting other agencies. No. But the Vietnamese legislation on considering, on handling the infringement of a right, the Vietnamese legislation does not require a decision on examination. The state regulators, they need to enhance their capacities. And there is only one single agency to give the opinions on a single case, a single matter, and that would depend on each person's wishes. One would say there should be many examining agencies. To put it simply, I will ask for the opinion from this agency, but maybe the response is not satisfactory to me, so I turn to another agency to ask for their opinion, for their comments, until I get a comment, an opinion that I am happy with. And sometimes re-examination is required, so they want to have as many examining agencies as possible, so that they can get the approval from this or that examining agency. So the fact that different agencies have different views is something quite normal. So the decision shall be made by the agency which want to implement the rights of the right holders. And I would like also to comment, because this point has been raised by many people. It is the objection letter to Madrid and The Hague. When Ms. Yen mentioning the commercial name, were you in the room at that time? Not yet. So in a nutshell, the Hague and Madrid procedures were originally very facilitating when we do lots of legislations because they have ensured the consistency of the procedure. When once we have achieved that, you see that usually the procedures of countries are different from each other. For example, for the Madrid application, the answer must be provided not more than 12 months later. In line with the domestic law, when the petition application used as the control document for giving a rejection, a refusal. And in Madrid, they also have the partial and temporary refusal, right? So Mr. Martin also comment about that. Many countries in the world, I know that they follow the orientation of minimizing the objection before issuing the certificates. So, but what matters is that to make the objections to be made after the granting of the certificate, to limit the possibility that the timing for handling the application might be lengthened. So for The Hague or Madrid, you can find some kind of conflicting issues when IP Viet Nam have to comply to that. So that is why, at least at present, in the legislation, there are no such things. But we still have the channel, which is Article 112, entitled the opinion of the third party. So in line with the Vietnamese legislation, that is so.
A short comment about this international registrations of designs and trademarks. Also, the system in Vietnam is different than the system in Europe, because in designs we do not have substantive examination of designs. So because we have no substantive examination of design, we have no examination of design, there is no opposition. So what we do is, when we get an international registration of a design, then we just check one formality and then it is registered. There is no examination and there is no opposition. In trademarks it's different. In trademarks, because of course we do an examination on absolute grounds, there is an opposition. And therefore, you said in your presentation that industry would like to have an opposition before examination in international registrations. This can be possible maybe under Vietnam law, because they may have done the declarations accordingly, but we don't have it in Europe. So I cannot comment from the European perspective to the Vietnamese law, because the European law is different.
Vâng, cảm ơn ông ạ. Vâng, anh Tùng có muốn...
Thank you, Mr. Tung. Would you like to add with some comments? And also the floor is open to you. Mr. Tung, please. I only want to have some comments related to the legal responsibility of ISP. In fact, the nature of this regulation is that we want the ISP to cooperate with the right holders and the state management agencies in preventing infringements. So the state management agencies or the regulators are always ready to cooperate with the ISP in finding the most effective mechanism and solutions to prevent and to remove the infringing contents on the digital environment. Secondly, on the role of the right holders, yes, they are the owners of the intellectual property, so they shall be proactive and active in coordinating with ISPs and the competent authorities in preventing the infringements, because more than anyone, the right holders, have lots of information and experience in detecting and preventing the infringement to their assets, to provide to ISP and competent state authorities in handling the cases, in handling the issues. So, do you have more questions or comments? I give 5 more minutes for you, ladies and gentlemen, especially Mr. Martin, Madam Sulu, and you all. So after one hectic, active working day in line with the schedule, starting at about 9 a.m., ending at noon, and now nearly 17 or 5 p.m., we have completed the agenda. And first of all, on behalf of the leadership of the IP of Vietnam, I'd like to express our sincere thanks to the IP key Southeast Asia project, coordinating with the IP office of Vietnam. And thank you, Mr. Martin, the counselor of IP of EU in Thailand, and the team of project management from Thailand, and especially the experts, the speakers, for sparing the time, preparing the presentation, providing information, and discussing with us. And also, thank you all for sparing the valuable time in the busy schedule to participate in the workshop today. We think that our workshop is successful because but we still have more issues to discuss further with more time needed. For example, the series of opinion from Ms. Yen in her last presentation. I know that this is the voice of the enterprises, the business community, which would expect the responses from Vietnamese regulators and law enforcement agency. Due to the time constraint, we cannot respond to all of that. We hope that there will be other opportunities to discuss with each other to improve the system, and especially the implementation. The text of the legislation is very standardized, but what matters is the implementation. For example, for examination, yeah, Ms. Ian mentioned the famous brands. It is not that she does not understand the law, but in reality, IP Office of Vietnam was somehow too difficult to accept that this or that is a famous trademark. So I know that what is even more important than having the legislation is to implement it. So once again, we thank you all. We wish you all good health, happiness, and success. Thank you. I would like to declare that our workshop adjourned here. Thank you.